He readily accepted and said that which area I would speak. So I requested him that the most important, area of relationship for a lawyer in his professional life is with client, and client in balance with court and other things. So I requested him, sir, with your such a long and vast experience with every sphere of legal profession, if you can provide us such lecture, it would be just not simply, intellectual enrichment for us, but it will be a guiding factor. And I just recall Justice Abbott Perry had written a book called Seven Lamps of Advocacy, and he highlighted 7 important components that makes advocacy a challenging as well as a extremely important faculty, and the last one was fellowship. So fellowship, he explained, was that in that tradition of English lawyers, you generally have somebody before you who will handhold you to the profession, who will help you to develop your profession, and he will be your inspiring, guiding, leader for remaining part of your professional life. And I think today Justice Kabir's lecture on this particular aspects will be all for us like a guiding lamp for our coming professional endeavor. So without taking any further time, I request sir to kindly.
Can I use this?
Yes, sir.
Sitting here.
Maybe I can provide.
No, this is fine as well. Stand up.
Good morning to all of you. Thank you, Professor.
This is basically a very dry subject, isn't it?
Lawyer-client relationships. Apart from that, lawyer-judge relationships. These are basically very, very dry subjects. But this subject is of great importance to those who are part of the legal fraternity or going to be part of the legal fraternity in various different disciplines. I do have the advantage of 2 or 3 things, and that is that I had practiced for many years, and then I became a judge. While practicing, I had a great deal of experience both in the trial courts as well as in the High Court as well as in the Supreme Court. These are phases which you may also go through if you choose to go in for litigation. Otherwise, if you choose to go in for other aspects of the legal profession, you would still have to remember and understand the various the various ethical duties that you have towards now not your client, but maybe to the person who has employed you. Maybe in a multinational company, maybe in a law firm, but all the principles that are required, that are necessary, are all important wherever you may be in the legal profession. In fact, I'll tell you how I came into the profession. I was in class 8 in school, and our civics and social sciences teacher, I remember him very well, it was more than 55 years ago, one Mr. Hon'ble. He had set a paper for an examination in the social sciences and ethical class, in which various questions were set by him referring to how a citizen ought to behave in different circumstances. I'm not boasting, but I did come first in that particular paper. And Mr. Hon'ble told me, Kabir, that's the way they used to call me in school, Kabir, I think you should become a lawyer. Why? Because the answers that you've given are answers which are right, very basic concepts of how a person should behave in society and how a person should be ethically and morally armed to deal with problems. After that, there was no looking back. I stuck to my intention of becoming a lawyer, and I did not become a lawyer by accident, but by choice. I was in a boarding school, and when I came out of the boarding school, the culture shock that I got was simply unimaginable. I cannot think today of waiting for an exam in an examination hall with the invigilators providing you books and slips to write your answers from. I went through all that. All this was some kind of a rude awakening that you're in now, or you're in a jungle where you have to prove yourself, show yourself, where you have to show that you stand out from all the others. And that is where all these things about morals, ethics, discipline, how to behave with others come into play. After joining the profession, again there was a culture shock. I had no means of knowing what to do, who to approach, how to go about my attempts at becoming a lawyer. Fortunately, I got the guidance of a very senior man and one of the few people with such ethical behavior. At one point of time, he was the senior counsel for the state of West Bengal in the High Court. They used to be called senior standing counsels. From him I learnt a lot. Mostly learning how to behave in court, learning how to address the court, learning how to tackle a situation which may arise without offending the court. These are all part of experience, and before I go into that, in fact I had decided that let's make this little talk a bit interesting. You know that stories always help to connect a speaker with the audience. And I thought let's begin with a few stories which I have personally experienced during my judicial career and also as an advocate, so that you could also get a feel of things as to what you also may experience as you go out graduating from this college, university. The first incident that I'll talk to you about is I don't know whether I've told you this before, maybe some of you may have heard of it, and that is there was a very tough lady judge in the Supreme Court, in the High Court. Have you heard this story before? No. Very tough judge. There were 4 judges who were appointed, 4 women judges appointed at the same time. One was an absolute dear. Some of them were alright, but this one was a terror. But people didn't know her. She is, on the face of it was a facade that she put on to be able to stamp her authority. I don't know whether you've heard of a lady judge in the Calcutta High Court called Justice Padma Khastagir. In case you haven't, she was basically a lawyer on the criminal side, and she appeared for the CBI in many cases. In her court, however, a suit was being, thank you, in a kokun khabu. It was a suit which was being heard in her court. And I was then a very raw junior, say about roughly 3 months old. And I was told by my friends, go and sit in the courtrooms, see what happens in the courtrooms, and try and pick up the nuances of practices. So I happened to be in the court of Justice Altamas Kabir, where this suit was being heard, and an old solicitor, must be about 75 to 78 years old, I forget his name, he was making his submissions before Justice Kabir. He had nobody to help him there. He was alone. And you know, in the courts, we have this kind of a little table on which a person can keep his papers or her papers and rest their hands also. So he had his papers on that particular table. While arguing, while making his submissions, some of the papers slipped and fell down. Fell down just under the table. I mean the main table, and it had fallen to the floor. There was a large number of people inside the courtroom, large as in quite a number of people in the courtroom, including lawyers. But nobody moved an inch. Here this old man was floundering. He had lost the connection between what he was saying, because the next page was under the table, on the next 3-4 pages. I waited for a while, and this is the culture shock I'm talking about. Nobody would seem to move. I got up, picked up the papers, gave it to him. The old man was so grateful because he didn't know what to do. He was in great trouble. I went and sat back in the benches at the back, and then Justice Kabir stopped the proceedings. He asked me who I was. Then she said, it's rarely in court that we see this kind of courtesy, where an old man who's having problems is helped by another person, an advocate inside the courtroom. It was nothing. It was a very simple little thing that was done. And in fact, from the teachings and the experiences I've had in school while I was in the hostel, this was par for the course. If somebody papers fell down, you just picked them up and gave it to them. But this was a big deal as far as the court was concerned. And believe me, from that day onwards, the terror of the court became one of my best friends. Justice Altamas Kabir and I became, we were able to converse with each other, think with each other on the same wavelength. All it needed was that little bit of courtesy shown to a man and shown to the court. This is part of ethical behavior. This is part of behavior which befits an advocate. Because an advocate, I'll come to that little portion later, an advocate, as soon as he takes that oath and wears the gown, he is uplifted in the eyes of society to a certain position where society looks up to such people. This is one experience. And the experience is the lesson that it doesn't pay much to be courteous. It doesn't pay much to be helpful, in a court of law or outside. The second experience I'll talk about is, my senior, as I told you, was a very, very old man. One of those people who were from the British days. You know, their outlook at things were totally different. They could never think in terms of telling an untruth to the court. This old man suffered from problems in both his knees. He had arthritis, and he was very heavy also. I'll tell you his name. He was Mr. Jitendranath Ghosh, who naturally you would not be knowing, but during the freedom struggle, Mr. Sharad Bose, have you heard of Sharad Bose? Yeah. Netaji's brother, elder brother. He used to run a newspaper called The Nation. Mr. Jiten Ghosh, he gave up his practice during this period or during the independence movement, and he started editing the Nation. Mr. Ghosh had this problem, as I said, but he also used to go to apart from the High Court, he used to go to the trial courts. That is something I'll come to you a little later also to explain to you, to talk about. He used to go to the trial courts. Now, in the trial courts, it meant either going to the City Civil Court, which is next to the High Court, or going to the Alipur Court, which is at quite a distance from the High Court. Now, Mr. Ghosh told me to go through the appellate brief of a criminal appeal. And he said, you go through it thoroughly, read it thoroughly, be prepared with all the facts. You'll have to assist me in the case. His nephew also was in the same chamber. He refused to take up the case because there were no fees involved. Very well. So I read the entire brief back and forth till I knew what was there between the first page, the first cover and the last cover. The day the matter was listed for hearing before the senior most criminal bench. Sorry, just let me take a sip because he brought it. The senior most division bench, consisting of a former Chief Justice of India, Justice Shobhashachi Mukherjee, and Justice Orunjana. I still remember those two gentlemen. Orunjana was a little stiff. Shobhashachi Mukherjee was a little more liberal. So Mr. Ghosh told me, look, the matter is in the list today. I'm going to Alipur for just about 10-15 minutes. I have to say something there and come away. So ask for an adjournment for about 15 to 20 minutes. I'll be there. So when the matter was called, that was the case, criminal case which was fixed, the only case which was fixed for hearing that day. So when the matter was called, I told the judges what I had been told to say by Mr. Ghosh. And the judges is fair enough because Mr. Ghosh was a very senior counsel and people respected him a great deal. So the judges said, fine, there's no problem. Let him come. We'll wait for about 20 minutes, let him come. Unfortunately, the 20 minutes became 30 minutes, but there was no sign of Mr. Ghosh still. Then the judges said, I'm sorry, we are sorry, but I don't think we can wait any further. We have no other option but to dismiss the appeal for non-prosecution. Now what to do in a such situation like that? There again, I was hardly about 4 months into the profession. But because of the advice which he had given, that read the entire brief thoroughly, I knew the brief and I said, my lords, instead of dismissing the appeal, would you allow me to argue it? They looked pretty surprised. But Justice Shobhashachi Mukherjee said, yes, go ahead. And go ahead in your own way. You don't worry. Say what you have to say. I knew the judgment was about 60 pages long. And I thought the best way to kill time was to read the judgment. At the same time, acquaint the court with the facts of the case. So I told the Honorable Judges, can I read out the judgment? Because that is the basis of the factual as well as the legal aspects of this appeal. The two of them smiled, but they said, yes, go ahead. And I kept reading the judgment, and while reading the judgment, also referring to the various facts and the manner in which the evidence had been brought in, what the evidence was. It continued till lunchtime, lunch recess. No signs of Mr. Ghosh. After lunch, I thought he'd be there. Even after lunch, he didn't come. So at 2 o'clock, I had to continue with this judgment. And we continued because the judgment was a long judgment, and we continued even beyond sitting hours. We normally get up in the High Court at 4:15. That day we continued till 4:30 until the judgment reading was completed. The judges got up, and 15 minutes later Mr. Ghosh comes in. What happened? What happened? My name is Altamas, as you know. What happened, Altamas? I said, sir, this is what I've done. Later on, he told me that Justice Shobhushaji Mukherjee, the senior judge who became the Chief Justice of India, phoned him in the night and asked him who I was. I didn't give any details about myself when I started, and I said I wouldn't. He found out from Mr. Ghosh who I was, what family I belonged to, this, that, and the other. The next morning, when Mr. Ghosh was there and the matter was called at 10:30, he began to apologize. I'm so sorry that I was not here yesterday when the matter was called. So the judges said, why are you apologizing? Your junior kept us occupied the whole day. Now, the moral of this story again is, because I figured in it, I said let me try and also refer to these. The moral of this particular story is that when you go before a court of law, in any capacity, as a junior, as whatever, you should be thoroughly prepared with your brief. This is what you owe to your client. You should be thoroughly prepared. You must know each and every fact, details, law. If necessary, you must also research your law before you go into the court, in whatever capacity. You may be called upon in a sudden situation to face the court and be able to hold the court with your submissions, with your approach, at least till the Marines arrive. That means the seniors arrive. This is the second story. The third story does not involve me directly, but it does involve me in a certain capacity. I had a client whose case I was dealing with in the High Court. But as you know, under Article 226 of the Constitution, various orders are challenged and can be challenged. But this client also had a civil problem, a problem involving the civil law. So I asked one of my friends, colleagues, as to who I could entrust that case to. A suit had to be filed, a suit for declaration and title, and injunction as well. So the name of a particular advocate was suggested, and I requested my client to go and meet him, and whatever was required to be done, he would do it. After almost 2 years, my client came to see me in connection with the High Court case, and I asked him what was the progress in the civil suit. He said the suit has been filed, dates have been given for written statement, for first of all for return of service, then written statement. Thereafter, if anybody wanted to discover their documents, the normal procedure that is there when a suit is filed, and the procedure under the Civil Procedure Code. So he brought the number of the case, the suit and everything. Somehow or the other, I was not being able to satisfy myself that this man had been acting correctly. So I sent somebody else from the High Court to the Alipur Court to find out from the record section as to what was the real stage at, because he could not give the stage as such. To my horror, I found that the suit had not been filed at all. A lawyer's responsibility to his client. The suit had not been filed at all, and a manufactured number had been given to the suit, manufactured dates, and for 2 years he had been taking fees every single day that the matter appeared. What would you call this? A lawyer's responsibility to his client? The fourth anecdote is about me again. I was still practicing in those days. I had not become a judge. Just prior to the 1990s. the room where I used to sit, room number 3 of the Bar Association in the High Court, there used to be a very good friend of mine whose brother-in-law, that means I think it was his wife's brother possibly, who was dealing with income tax matters. So this gentleman, I won't reveal his name, he says, why don't you allow this person to handle your income tax matters? He can file the returns, whatever has to be done, he'll do it. Later on I became a judge. He used to come and get, these forms which are to be returned, which are to be filed, signed each year. And I knew that the matter was being looked after, I didn't bother very much. After I became a judge, I still continued with him until a question cropped up with the income tax authorities regarding my non-filing of returns. Again, I was shocked. I found out later that he had not filed a single return, although he had been taking his fees, his money and everything. These are just examples of how a lawyer should not behave or should behave before the court. I thought I'd start with these few these stories, which are all real stories, and there's nothing which is not true. Each story is true. So now, as all of you know, lawyers are governed by the Advocates Act of 1961. You must be knowing that. And the subsequent rules which were framed by the Bar Council under the Act, Section 49 of the Act, rules were framed. While the Act provides, the Advocates Act provides for the norms which are to be followed when an advocate is to be enrolled in the bar, and the things that are required to be done, the Bar Council rules. The Advocates Act, as you may be knowing, is the act under which the Bar Council was formed, constituted. Both the Bar Council of India as well as the state bar councils. And the bar councils were given the authority to make rules. And it is under the authority given to the bar councils that the bar council rules were framed. Have any of you had an opportunity of reading the bar council rules? I think you should. The reason being, this is what gives the manner in which, or sets out the manner in which an advocate has to deport himself or herself in any situation. I have rarely come across a set of rules where a particular chapter begins with a preamble. I don't know whether you have, but I've rarely come across this. Part 6 of the Bar Council rules contains 2 chapters. We're concerned with the second chapter. This is of course, this particular part 6 deals with ethics, morals, as far as advocates and lawyers are concerned. Chapter 2 is what I'm concerned with basically, and chapter 2 begins with a preamble. I'll read that preamble for you because I feel that it is extremely important that anybody planning to become a lawyer, planning to become an advocate, needs to know and understand. It goes like this. An advocate shall is a preamble to the chapter 2. Standards of professional conduct and etiquette. An advocate shall at all times comport himself in a manner befitting his status as an officer of the court. don't forget, an advocate is always referred to as an officer of the court. That means representing the court itself. As an officer of the court, a privileged member of the community and a gentleman, bearing in mind that what may be lawful and moral for a person who is not a member of the bar, or for a member of the bar in his non-professional capacity, may still be improper for an advocate. Look at the standard, look at the status to which an advocate is elevated. That what may be lawful and moral for a person who is not a member of the bar, or for a member of the bar in his non-professional capacity, may still be improper for an advocate. All of you are going to go out into the world as you pass out from here and will enroll with the bar councils in the states or in the center. You become an advocate that very same day as you become an advocate. You are raised on a certain pedestal. People look up to you. Without prejudice to the generality of the foregoing obligation, an advocate shall fearlessly uphold the interests of his client, and in his conduct conform to the rules hereinafter mentioned both in letter and in spirit. The rules hereunder mentioned contain canons of conduct and etiquette, adopted as general guides. Yet the special mention thereof shall not be construed as a denial of the existence of others equally imperative, though not specifically mentioned. Those are the common law or the common social modes of conduct. Section 1 of this particular chapter, chapter 2, deals with the advocate's duty to the court. This is divided into 3 different sections. One is the advocate's duty to the court, advocate's duty to his client, advocate's duty to his colleagues, advocate's duty to his people on the opposite side in a case. Section 1 refers to duty to the court. Because these are important, I'll read them out. As I said, it can be a little boring at times, this kind of a subject, but I thought I'd cheer you up with the other stories. I've still got a few more. An advocate shall, during the presentation of his case, and while otherwise acting before a court, conduct himself with dignity and self-respect. He shall not be servile, and whenever there is proper ground for serious complaint against a judicial officer, it shall be his right and duty to submit his grievance to proper authorities. An advocate contains quite a punch in him. And if he feels that his client is being wronged in the court, he can protest as well as protest verbally, as well as in writing before the concerned authorities. An advocate shall maintain towards the courts a respectful attitude, bearing in mind that the dignity of the judicial office is essential for the survival of a free community. Just digressing for a minute. You remember about, say, 2-3 months ago, there was an incident in the Adipur court regarding bail of a particular political person. And the man, the presiding officer of the court, was not allowed to pass orders till 8 o'clock in the night, and he was in his chamber. He refused to get up and go. His name is Hon'ble. He stood his ground against more than 200 to 300 lawyers who had entered into his courtroom and his chamber to try and force him to get up and go and not pass the order. He refused to do so. He passed the order late at night and then went away. Those 200 to 300 lawyers who had rushed into the court to try and prevent him to pass the order, do you think their attitude, their behavior was correct. I had been asked by the press about this incident. This would constitute contempt of court. What do you think? Any of you? Would it be contempt of court? Nobody? It would definitely be contempt of court, there's no question about it. But the thing is, do you proceed against all those 300 people? How do you proceed? How do you go ahead with it? As a result, contempt proceedings, I said, are not very feasible. It requires, it's more a law and order problem. It's more a rule of law problem. And it also required a certain amount of counseling to those lawyers who entered into the courtroom in that fashion. This brings me to a second topic out of this itself, and that is advocates from all across the spectrum. They have to be united as advocates, not as members of political parties. What happened was a show of strength by members of a political party. They were not acting as lawyers, they were acting as agents of a party. This you cannot afford to do in case you want to maintain the dignity and sovereignty of the courts. I just now read out a little while ago, to maintain the dignity of the court. If the court system collapses, who benefits? Where do we go from there? The day the lawyers do not respect the presiding officer of a courtroom, that day the judicial system is more or less destroyed. We call this a noble profession. The nobility in the profession means, or rather is enjoined in the way in which we behave with each other. We call our friend, the members on the opposite side, my learned friend. He's on the opposite side. He's the opposing lawyer. He's going to fight tooth and nail against you. But it's always my learned friend. It was a gentleman's profession. It should continue as a gentleman's profession if one has to keep the judicial system in order. Who tends to benefit the most if the judicial system is destroyed? If the judicial system is weakened, who stands to benefit the most? This somebody can say, some answer. Who stands to benefit? Obviously, the political masses, obviously the administration. If the judiciary can be kept under control, if the judiciary can be a purchasable commodity, then you can get whatever you want. That is where, when I was in Delhi, I had this regular clash between the Ministry of Law and the courts regarding the National Judicial Appointments Commission. I don't know whether you know how it is formed or what the composition is, but it is weighed towards the executive and not in favor of the judiciary. In a situation like this, the government, which is the largest litigant in the country, stands to gain. They can put in their people if they want to. The collegium system has been condemned by many people who have their own vested interests. It's not that the common man or anybody who understands wants this kind of a change. There is a certain section may, but it is the judges who know the judges practicing, functioning in the different courts. In my time, I used to know almost all the district judges, not even only the High Court judges, all the district judges in the country. I knew each one of them, how they functioned, how they worked, their integrity. This is something which we also knew in the High Court level. We were the better judge, in fact, of knowing how a judicial officer has been performing, what he does, what kind of a person he is, what kind of attitude he has. And that is how appointments were made. There could be one or two mistakes, definitely. I don't say that the system is absolutely foolproof. A person may show something when he's being considered, an attitude when he's being considered, and that attitude may change absolutely radically once he comes to the courts. He's raised either elevated as a judge of the High Court or the Supreme Court. But that is a matter of judgment which can go wrong at times. But we know how they function and how they work. So, as I said, I was quite against this because I didn't want that there should be government interference so that the right people could be selected to the courts. This was one of the aspects of an advocate maintaining towards the courts a respectful attitude, bearing, because it's just not only the manner in which you may be able to address the court. Some, I don't know whether you had experience of going to the courts, some thump the desk, some put their legs up on the bench. This has become a part of the way things are. Some shout at the top of their voices, senior lawyers, barristers. Have any of you heard Mr. Ram Jethmalani arguing? You have? No. He is full of sound and fury. What are the other words of Shakespeare? From Macbeth? Okay, doesn't matter. I won't add those words. So, this is a kind of advocacy also, where you shout and scream your head off. The judge is not buying anything what you're carrying on. It's also like playing to the gallery. These are things which possibly you could avoid when you go into the arena as such. This is part of the rules which have been framed with regard to how a judicial person, what is his duty or her duty to the court. Then, an advocate shall not influence the decision of a court by any illegal or improper means. Private communications with a judge relating to a pending case are forbidden. An advocate shall use his best efforts to restrain and prevent his client from resorting to sharp or unfair practices or from doing anything in relation to the court, opposing counsel or parties which the advocate himself ought not to do. An advocate shall refuse to represent the client who persists in such improper conduct. He shall not consider himself, now this is very important, I feel, to those who are budding lawyers. An advocate shall refuse to represent the client who persists in such improper conduct. He shall not consider himself a mere mouthpiece of his client and shall exercise his own judgment in the use of restrained language in correspondence, avoiding scurrilous attacks in pleadings, and using intemperate language during arguments in court. These are the duties which are now being followed, but in the breach. You will find in very many petitions, very many applications of the court, straight away allegations are made against people, against even the advocate on the other side, forgetting that these things are there. But the reason being, nobody reads these rules. Maybe even the judges are not aware, otherwise they can hold them up. Then, an advocate shall appear in court at all times only in the prescribed dress, and his appearance shall always be presentable. This is followed mainly in the High Court and maybe in some district courts. But if you visit any of the criminal courts of the state, the districts, or even Bankshal Court here in Calcutta, or the Syada Court, you will find our poor advocates not even concerned as to how they're dressed. We say that, well, after all, how many of them can afford? But that's not right. If you want to maintain the solemnity and dignity of the profession and the courtrooms, this is compulsory. You must appear at least with the hair combed. You must appear at least with your shirt at least white and not grey. Grey not by itself but by dirt. And just a common torn gown. You have to represent yourself as a person who is looked up to by society. Of course, when you go to the corporate world, you have to be dressed well. There is no other option. And some of our young lawyers who have passed out recently from the various universities, and I've had a chance to meet many of them, all of them were impeccably dressed. But I'm talking about the general lawyers. An advocate shall not enter appearance, act, plead or practice in any way before a court, tribunal or authority mentioned in section 30 of the Act if the sole or any member thereof is related to the advocate as a father, grandfather, son, grandson, uncle, brother, nephew, first cousin, husband, wife, mother, daughter, sister, aunt, niece, father-in-law, mother-in-law, son-in-law, brother-in-law, daughter-in-law, or sister-in-law. So you cannot appear before any of these persons. Or even if these persons are practicing in that particular court. But unfortunately, again, this is followed more in the breach. And you will find that many relatives, kin of judges do practice. Not in that particular courtroom maybe, but in the court otherwise. An advocate shall not wear bands or gown in public places, other than in courts except on such ceremonial occasions and at such places as the Bar Council of India or the court may prescribe. You know the bands that we wear and the gown. I have seen this happening in Delhi. I have not seen it much here. A person practicing, say, in the Patiala courts, which is near Connaught Circus, and we had the, not Connaught Circus, what do you call it? The India Gate. Those who are practicing there, on the Patiala court, maybe has a case in Saket, which is in South Delhi. I've seen, they jump onto the scooter with their gown, with their bands, with everything on, traveling from between one court to another. In Delhi there are distances. But they will go with the bands on, collars if they at all have any, and their gowns. Travel between Tesazari court, then Patiala court, the other courts. This is completely forbidden. You'll find lawyers walking around on the roads with their gowns and bands. You can't do it. But unfortunately, as I said, it's all in the breach. That is why there has been so much of a deterioration in the ethical and moral culture of our legal profession. An advocate shall not appear in or before any court or tribunal or any other authority for or against an organization or an institution, society or corporation if he is a member of the executive committee of such organization or institution or society or corporation. This is the lawyer's duty to the courts in general. Now, duty to the client, there's a section 2. It says, an advocate is bound to accept any brief in the courts. An advocate is bound to accept any brief in the courts. You cannot say, no, I will not appear. Why? Because he's a murderer, he's done this, he's done that. You find at certain times entire bar decides not to appear on behalf of a certain person who may have been accused of either murder or rape, things which are very heinous crimes. Bar Council rule says, no, you can't do that. It says, an advocate is bound to accept any brief in the courts or tribunals or before any other authorities in or before which he proposes to practice at a fee consistent with his standing at the bar and the nature of the case. However, special circumstances may justify his refusal to accept a particular brief. Now suppose a lawyer happens to be the brother of a victim girl who has been raped. In such a situation, yes, he can always say, no, I will not accept this brief, to defend the accused. Then there are all these things which go on to say that an advocate should not appear where he may be appearing as a witness later on. An advocate appearing for the prosecution of a criminal trial shall so conduct the prosecution that it does not lead to conviction of the innocent. The suppression of materials capable of establishment the innocence of the accused shall be scrupulously avoided. An advocate shall not directly or indirectly commit a breach of the obligations imposed by Section 126 of the Indian Evidence Act. If an advocate